Well, thank you very much, Marshall. Thanks to the panel. Let's see if there's any responses to anyone, any comments. Mike, do you have anything that you'd like to add?
Just one thing that Victor reminded me of, and I would like to, this is important to mention. You all were very kind about some aspects, or maybe a number of aspects of the third restatement. I should tell you that Gary Schwartz, who was a professor at the University of California at Los Angeles, was the reporter for this physical and emotional harm restatement from about the mid-90s until his untimely death in July of 2001. Gary was, in my view, the torts person, the titan of my generation of torts scholars. We have missed him tremendously since his death. He made enormous contributions, and much of this restatement, including the negligence sections to which you were adverting, Marshall, were prepared by Gary. I only wish that he were here today to see the fruition of his work. In significant respects, all that Bill Powers and I did since his death has been a caretaker of a huge chunk of this that Gary prepared, and prepared brilliantly. I'm sorry he's not here with us.
Victor or Marshall?
Well, I will go in the order, I guess. I want to make clear that, because there could be some ambiguity, that I think in the current draft, the restatement does create a duty to trespassers. In other words, all the categories are gone, and the Supreme Court of Iowa kept the no duty to trespasser rule with its traditional exceptions, but got rid of the licensee and invitee point. Marshall is always so articulate. I listened and learned phraseology from him. Mentioned a good deal about the products restatement. The reporters from the restatement on products aren't here, Rabbi Twersky and Jim Henderson, and I know that they struggled with this point, and it was interesting to me and intriguing that there was all this battle over reasonable alternative design. The black letter says you have to show a reasonable alternative design to win a design case. Well, I'm in a large firm, and I've talked to people who are litigators. Shikardi and Bacon it's Midwest, it's Kansas City. There's over 230 people have tried jury cases. And everyone says that in design cases, the plaintiff shows the jury some alternative design. Otherwise, they don't get any damages. So there was this debate in theory, and then there's the real world of litigation. And I've been trying for a long time to find out what the debate is all about, and I finally understood why the plaintiff's bar was concerned about RAD. And that had nothing to do with the rule, it had to do with Daubert. The fact that it was difficult sometimes for them to get an expert through the Daubert screening process to show reasonable alternative design. It's just a thing of the academic world and the real world that I wanted to share with you. And very quick word about the ALI. It is a great institution. It gets controversial. And they have, after 25 years, you're admitted as a life member. So they broke the rule with me and allowed me in before I was 35. They had never done that before. And they have this ceremony when you're there 25 years, and people are sitting around, they're all saying something important about their careers and what they did. But I just made this observation. Henry, they never broke that rule again. They learned their lesson.
Marshall, do you want to add anything before we throw it out for questions?
Just this weekend, I read a seminar paper from an excellent student who made somewhat the same point, and that is the linkage of that doctrine to Daubert. And I think that that's a very good point, but I will say that I think that there is a real tension when the ALI gets into the business of subjects like products liability. And I found it particularly interesting reading the article that I cited from Hans Linde, that he concluded after highly praising traditional non-policy style decision-making, that the ALI should not avoid controversial topics of legal policy. And then in the next sentence from his lecture, he said, policy making must be prepared to face politics. So I'm ready for questions.
Well, thank you, Marshall. It reminds me of when you mentioned the restatement of corporate governance. It was actually a restatement and recommendations, which I think was part of the battle about what they were going to call that.
They called it principles.
Yeah, principles of corporate governance, restatement, or principles and recommendations, right? Yeah. Is that what it was? Right. But that was kind of, it seemed to be venturing into new territory with the recommendations part, at least explicitly venturing into new territory on that one. Well, do we have any questions for this panel? You need to take advantage of these folks up here. Going once, going twice. All right, we're going to break early. We're going to take a 20-minute break and come back with the next panel. Please join me in thanking these folks.